What is corporate veil? After an incorporation of a company, the company itself and the members in it are treated as separate legal entity. There is a veil that divides the company and its members. What is lifting the corporate veil? The court will break through the corporate veil by applying the principle of lifting the corporate veil. It happens when there's any fraudulent and dishonest use is made of the legal entity. The members who committed the wrong liable will not be allowed to take shelter behind the company, and they will be personally liable for those debts and obligations. Section 36 of Companies Act 1965. It is prohibition of carrying on business with fewer than statutory minimum of members. If at any time the number of members of a company other than a company the whole of the issued shares of which are held by a holding company is reduced below 2 and it carries on business for more than 6 months while the number is so reduced, a person who is a member of the company during the time that it so carries on business after those 6 months and is cognizant of the fact that it is carrying on business with fewer than 2 members shall be liable for the payment of all the debts of the companies contracted during the time that it so carries on business after those 6 months and may be sued therefore. And the company and that member shall be guilty of an offence against this act. If the company so carries on business after those 6 months, 2,000 ringgit will be imposed as a penalty for offence of this act. Under Section 67, it is offence dealing by a company in its own shares. Section 67, Clause 1 has stated that except as is otherwise expressly provided by this Act, no company shall give, whether directly or indirectly and whether by means of a loan, guarantee, or the provision of security or otherwise, any financial assistance for the purpose of or in connection with a purchase or a subscription made or to be made by any person of or for any shares in the company, or whether the company is a subsidiary in its holding company or in any way purchase, deal in or lend money on its own shares. Under Section 121 of Companies Act 1965, publication of company name should be used in documents and transactions. Section 121(1)(a) and Section 121(1)(b) have stated that the name of the company, whether or not it is carrying on business under a business name, in legible Romanized letters and the company number of the company shall appear on its seal and all business letters, statements of account, invoices, official notices, publications, bills of exchange, promissory notes, endorsements, checks, orders, receipts, and letters of credit of or purporting to be issued or signed by or on behalf of the company. If default is made in complying with this subsection, the company shall be guilty of an offence against this Act. Under Section 303, Clause 3 and 304, Clause 2, wrongful trading, the court can make a declaration that when a company has become gone into insolvent, the director who knew or should have known there is no reasonable or probable expectations of the debts being paid, but still continues to contract debts, will be guilty of wrongful trading and liable to personally pay the debts to creditors in the event of the company's liquidation. Section 304, Clause 1, fraudulent trading. This concerns fraudulent trading. Under that section, if it appears to the court that the company is carried for any fraudulent purposes, the court may hold any person who were knowingly parties to the fraud personally responsible for all or any of the debts or other liabilities of the company as the court thinks proper. Let's see the next section, which is Section 305, power of court to assess damages against delinquent officers. Based on Section 305 Companies Act 1965, any officer in the company who misapplied or retained the company's money or property shall be liable to restore or repay in the event company is wound up. This is following the principle separate legal entity, as a company's money or property belong to the company and not the officer. If an officer misapplied the assets, he is liable for breach of trust. Similarly, if he retained the asset, he is actually holding the assets in trust for the company. Section 365, Clause 2, Clause B, payment of dividends out of capital. Section 365, Clause 2, Clause B of the Companies Act 1965 allows the court to lift the corporate veil in cases of dividends are paid even though there are no available profits out of which to pay them. Then directors who declared the dividend will be liable to pay the debts that the company is unable to pay the creditors when due, to the extent by which the dividend exceeds the available profits. Section 46 EPF Act, Contributions to Employees' Provident Fund. Sometimes, the employer may have deducted the salaries of its employees but failed to remit the contribution to the fund. It is an offense not to remit the contribution to the EPF. The Employee Provident Fund is a compulsory savings for retirement plan for employees in Malaysia. The employer and employee are to contribute a minimum of 12% and 11% respectively of the employee's salary to the fund. Lastly, we have Section 108A, Contribution to Social Security Organization. The Employees Social Security Act, 1969, established the Social Security Organization, SOCSO, to implement employees' injury insurance scheme for the benefit of the employees. Under this scheme, both employer and employee will contribute towards its premium. As in the EPF scheme discussed above, there are occasions where the employee fails to remit the premium to SOCSO. If the defaulting employer is a company, Section 108A of the Employee Security Act 1969 provides that the company, directors of the company at the time action is taken, and the directors at the time of non-payment are jointly and severally liable with the company for the unpaid amount. So let us see the case example of Guilford Motor Co. Limited against Horn 1933. Hi, my name is A.B. Horn. Hi, we're representing Guilford Motor Co. Limited. Mr. Horn was a former managing director of Guilford Motor Home Co. Limited. Mr. Horn was fired and he is prevented under his employment contract from being attempting to seek for Guilford's customers the moment Horn left Guilford's employ. I may as well just start a new company. He thus set up a competing company which undercut Guilford's prices. Not only he started a company same as Guilford, but also steal Guilford's customer. We should follow the legal restraint of our agreement. Clifford do not have any legal restraints upon Horn's company, only Horn himself that have legal restraints upon Guilford. Guilford commenced proceeding against Horn individually, claiming that Horn's company was an attempt to avoid legal obligation. So what's the issue? Had Hahn violated his non-compete clause by setting up his competing company? So, let us see what's the court held. So the English Court of Appeal held that the company was set up to avoid Hahn's contractual obligations. So the court pierced the corporate veil and ordered an injunction against Hahn. Courts can pierce the corporate veil if a company is simply a mere device to avoid legal obligations, though this is only in limited and discrete circumstances. So, for the conclusion, the corporation operates under the idea of the corporate veil, which was when the veil is abused for fraudulent purposes. It reveals the true nature and true beneficiaries of the company, also referred to as the lifting of the corporate veil. So the court used this rule on occasion and made a few adjustments that were appropriate for the circumstances and for future reference. Thank you so much for watching.